Welcome to the 137th edition of Europe Calling, today with Anna Cavazzini on the topic of the ECT. I would also like to welcome our two guests, Professor Christina Eckes and Fabian Flus. How do you pronounce your surname? Flus? Okay. Fabian Flus. My name is Maximilian Fries. I am the Managing Director of Europe Calling, and I will be your moderator tonight. And while I am just making some housekeeping remarks, I'm showing you the agenda for tonight so that you can have a look already. So now you can see that. So as always, during Europe Calling, you can ask questions, and as far as we are able, we're going to try and answer them using the Q&A function in Zoom. So please ask your questions in the Zoom Q&A function and then vote them up, and those questions with the most votes will be asked. So we'll need you to sort the best questions. And as always, everything is recorded, and then it will be live on YouTube, which you should keep in mind when you ask your questions. So we'll start with Anna Cavazzini. She is an MEP for the Green Party, and she has also issued a report for the Interior Market Committee, which has really focused on the critical attitude of the European Parliament on the ECT. Anna, thank you, Max. So it's the 137th edition of Europe Calling, and the second on the ECT, the Energy Charter Treaty. I think we had a while ago, we had another such webinar for the same reasons. It's a bad treaty and we have to leave it, but the topic is very complex as well, which is why we'd already had the topic on Europe Calling before. But that was a while ago. Maybe not everyone who's here tonight was there then. So I'll just like to explain what the treaty is about and where we are in the process in the EU, because of course the timing is no coincidence, because there are a lot of discussions ongoing in Brussels on what to do about this treaty, and our guests will then speak on that topic in a lot more detail. I'll just give you the broad framework. And then I think we're all looking forward to the discussion and the questions. So the Energy Charter Treaty is an investment protection treaty with many European contracting parties, but also other countries like, for instance, Japan or Kazakhstan as members. And it was signed in the 90s with the purpose to protect investments in fossil energy facilities, protect these investments, which sounds very positive. So it means that those foreign investors, countries can be sued at private arbitration courts. And of course, many of you will now understand what that means. So everyone who used to demonstrate against TTIP and CETA may remember these private arbitration courts. That was what many of us didn't like, and that's why we demonstrated against it, because it just gives a lot of power to investors. And because it means that even when a government takes a democratic decision in the interest of the public and supported by the majority, they can still be sued. This Energy Charter Treaty, I mean, there are lots and lots of claims under the ECT. There are other such investment protection treaties, but most claims come under this one, and another interesting factor is that most are intra-European claims. So let's say investors from one member state sue a state, the government from another member state, even though we're all in the same EU. I'll just remember all the issues and problems with this ECT. It's an old style treaty, which means there is no way of appeal. There are not even real judges. Often the persons deciding are just legal experts and lawyers of that area. And you can just sue against any decision by a government. So just to give you an example, Italy has just been sued by a British investor, Rockefeller, for 240 million euro because Italy has stopped oil well drilling in front of their own cost. And then the investor says, well, that changes my investment conditions, so I'll just go and file a claim under a private arbitration court. And there are many thousands other such cases, and I think that the other panelists will talk about that. So it was clear early on that this treaty is a problem. Civil society researchers and also other people from the legal community said that, protested and said that this isn't compatible with European law, which was confirmed by the European Court of Justice in 2 judgments. And then, of course, there was the discussion about the Green Deal and the Paris Agreement on climate protection. And we all know that we have to implement the Paris Agreement and we have to leave fossil fuels behind, phase out coal, leave behind gas and oil pipelines. And of course, this treaty, the ECT, is a barrier for our climate protection goals. And that's why the European Commission itself started a modernization, a so-called modernization process 3 years ago. So even the European Commission, and they're very much in favor of investor protection usually, said that we can't go on like this. But these reform efforts were difficult from the very beginning because you have to make every decision unanimous. So I think there's 52 or 53 contracting parties to the ECT, and Japan, for instance, said from the very beginning, never, we like it as it is. So many MEPs and many people from the civil society said, let's not waste time trying to reform the ECT, let's just leave it. And over the past few years, we've exerted pressure to do just that. Now, Max mentioned a resolution by the European Parliament that was adopted in spring this year on my initiative. The European Parliament has submitted a major reform proposal for private arbitration courts, also for other decisions, not just in the area of energy. There are other areas where foreign investors can file claims. So the European Parliament was very clear, saying that the ECT is incompatible with EU law. And a reform would have to be extremely ambitious. So fossil fuels would have to be completely excluded from any sort of investor protection. And reforms were blocked for a while then, until somebody in the EU probably had an idea and they said, just let's the contracting parties choose. So let's say that and the EU and anyone else who wants can embrace the reform, and that lifted that standstill. And then in June, July, the negotiations were finalized. We weren't even expecting it anymore. So that's the current situation with this webinar. In the EU, the Council and the EP will have to vote on this reform, with those negotiations being finalized, and all ECT member states will also have to agree with the reform. And so there's a lot of debate whether the reform is sufficient what the advantages are, what the disadvantages are, whether it wouldn't be best to still just leave after all. Then there are negotiations, there will be negotiations in the EP because the council always starts earlier. The council will have to vote on this reform very shortly. And many of you already know that individual member states have already decided that the reform is not enough for them and that they are going to leave. Poland, Spain, the Netherlands, and now lastly also France. Italy already left 3 or 4 years ago. So that means that already quite a number of European member states are very critical towards these reforms. But on the other hand, we have the EU Commission saying that it's still better to have the reform than to remain with the status quo. So, as I said, the other speakers will talk about the details of the reform. That's why I'm not doing it now. So the Commission says the reform would be better than the status quo, and we shouldn't be in the way of the reform. And if member states just leave the ECT, then the problem is that under the treaty, there's a sunset clause that means that fossil fuels investments will be protected another 20 years after leaving. So even if you leave, automatically there's a clause that says that that you're still bound to protect these investments for another 20 years. And that shows how important it is to really look at the small print when you negotiate international treaties like this, because they're very hard to change afterwards. So there are very different options and scenarios. So what's happening in the council, reform or exit or status quo, that's what we're going to talk about tonight in detail. So that's the background of the current situation. And of course, I'm happy to answer more questions after the other speeches.
Herzlichen Dank für diese Einführung.
Thank you very much for this introduction. And I would move directly to Professor Christina Eckes. She is a professor for EU law at the University of Amsterdam, and she's also the director of the Amsterdam Center for European Law and Governance. Professor Eckes, you have the floor. Thank you very much. Thank you very much for the invitation. I brought some slides along because it is my task to be looking at the legal side of things. And that is a bit more complicated, I should think, sometimes at least. And that's why I thought it's better to help us along with some slides. The first point was already mentioned by Anna. The current Energy Charter Treaty breaches EU law. We saw it in the judgment of Comstroy, and that means that both the EU and the member states have a legal obligation to end the status of illegality. We cannot continue with this situation. And then the Commission says, but yes, we've entered into negotiations in 2019, and the new proposed and reformed ECT is no longer in breach. But the Court of Justice said that we cannot have intra-EU an intra-EU system of arbitration, so that no investor from the EU can bring charges against an EU member state. And this has been taken up, but the reformed ECT still breaches EU law because it violates the Paris Agreement. And I would like to add in this respect that, yes, we do have a flexibility clause, which means that the parties to the contract of the ECT, namely, can say that investments into fossil fuels will no longer be protected after 10 years after it has entered into force. It can take, however, 3 to 4 years until it does effectively enter into force. And then we need to wait until 2/3 of all the parties have ratified it. But then it is a sort of procedure à la carte. So far, it was only the EU, the UK, and some other countries who said that they would wish to use the protective clause. Others did not. General Director Lenz of the Charter said, however, that this Charter should be enlarged by many more years. And the number of states, of course, is broadly extended, and then we will have a longer term waiting time to nationally reduce the emissions. And we're talking for the moment of emissions from Germany, France, Poland, and Belgium, for example. But the Paris Agreement really aims at reducing emissions around the globe. So the Energy Charter, even in its reformed state, is not better because it still is in breach with the Paris Agreement. I would also like to look at the latest developments with you. The Dutch government has communicated today that it will be quitting the Energy Charter Council. The minister in charge declared that on the 22nd of November, he will abstain in the council. So when they have their ministerial council meeting, he will abstain. And he also says that the Dutch government will not seek to ratify this reformed charter treaty. So it will not be submitted to the parliament, to the lower chamber, and they do not aim at having it ratified. Moreover, he also says, Anna already said that the European Council will be deciding on the 22nd of November and be giving directions to the European Commission. And here we hear that the Dutch government says that it is not yet decided which position it will take. And that is a great danger, because if a member state allows for the position of the Commission to be adopted, i.e., for example, by the European Council first and then the other treaty partners, that is a huge risk. And I would therefore propose that the major objective of those member states who wish to exit the treaty and all other parties who are very critical of this treaty, that they must definitely criticize very sharply the reformed proposal, and that they try to build and secure a blocking minority on the 22nd of November in Council. And I will be coming back to that and explain why this is so important. But I'll have to take a step back first. The ECT is a mandatory mixed agreement. The EU is one party and accepts the legal obligations under the treaty. That is a legal responsibility it takes on. We have on the one side the exclusive responsibility and competence of the EU for foreign direct investments, particularly in this area of energy investments. And on the other side, we have a judgment of the European Court of Justice, the opinion 219, who says that ISDS can only be legally required if all the parties agree to it. So we have a competence that cannot be taken away with the European Union and is thus also binding for the member states. So we need to create a situation where everybody really is on board. That means the European Union and the member states of the European Union, in order to make the treaty applicable to the entire territory of the European Union. The question arises, what happens if this is not the case? It is already no longer the case, because we know that Italy has already withdrawn in 2016, so one member state is already out. But the problem with such a mixed agreement is the strong loyal commitment that goes along with it, that you need to inform each other and cooperate with each other. So you're not really allowed to show any kind of approach which would be counterproductive to the approach of the joint EU position. So what does that mean in terms of the ECT? While the member states have a competency to take on board the ISDS mechanism, they are also in the driver's seat, and they can also build a blocking minority. Externally, the European Union always said that it would also regard the ISDS always as a binding procedure. The EU, however, has never allowed for any exceptions with the third parties in the treaty outside of the European Union. But legally speaking, she cannot go that far. The European Union cannot go that far. Now, Italy has already quit. The Netherlands, France, and Spain have declared that they wish to exit. And so we have a situation in the Council where we would have an illegal Council decision. And if it is not clarified that the EU can only co-decide for the rest of the ECT and not the ISDS, because that is the sole prerogative of the individual member states, then anyone can actually appeal against that decision, any member states or any other interested party. So that's the first problem with the Council proposal as is. The member states who have to agree can also exit the whole agreement or the treaty. They are international actors and they can decide on their own account. Those loyalty commitments cannot be binding on the member state to remain a member of a treaty forever, for example, which also has something to do with national competencies. So that is a rather complex situation. The European Union can remain a member for the FDIs, but not for the ISDS. Everything else would basically mean that we would redistribute the competencies. The member states would have no say in it any longer if the EU took on board all the power of a decision. We need a clear separation of power because the Parliament needs to be able to decide on what the executive should actually be doing. So the EU can only ever take on responsibilities and obligations within its mandate, properly speaking. And that is why basically the member states should vote against the ECT. We also need to think of the process of ratification, of course, but you first need agreement on the reformed wording. The first reason why everyone should vote against this is the climate, because fossil fuels in other states would still be protected, and it could be extended further beyond the actual present limits. And there's also a question of climate justice. Why would we wish to oblige 40 further member states or parties to this treaty to pay horrendous compensation within these arbitration processes, for example, because we are also interested in them getting along with the climate protection and the reducing emissions. And everything is really highly controversial because we're still looking for the right way forward for energy transition. It is very clear, for example, when you look at a biomass, which doesn't really improve the situation very much so far, but it is one of the avenues that was chosen by the other member states, or by some member states. And then there's perhaps a positive decision by the Council, which would then lead to an acceptance of this treaty, and the loyalty commitment to approve it in Council would be increased. Under European law, they would actually have to seek ratification.
Das sind zwei verschiedene Dinge, aber Ratifizierung anzustreben hieße jedenfalls.
So ratification would mean to ask the Parliament that they should agree to ratifying, which means that you cannot leave until the Parliament opposes. So that means that leaving the ECT will then be postponed to the future, which is the legal opinion on a situation where we have never had a judgment by any court. So what happens if a government, say the Netherlands, says publicly that they're not going to try to ratify it, but they might still decide to support in the Council? So they would support the joint strategy by the EU, because that's what the Commission wants. So how far does this obligation to act in loyalty go? And the court goes very far in order to assure unity of external representation, so that the EU speaks with one voice and that member states cannot undermine the EU's joint strategy. Thank you.
Ja, ganz lieben Dank.
Thank you. That was a lot of food for thought, I think, and it also cleared up the role of the member states and how strong that role could be. I've seen a lot of questions in the Q&A. I have a few questions myself, but Let's just continue with Fabian now. He works for an NGO called PowerShift for the trade and investment strategy. For this topic, and also the topic of other trade and investment agreements, he's one of the PowerShift is one of the leading NGOs, not just in Germany, but in the world globally. But I'm sure Fabian can introduce himself better than I could. Please, you have the floor. Thank you for this invitation. I'm going to share my screen with you. Hope it worked. My name is Fabian Flüss, and as I said, as was said, I work for PowerShift. We're a smaller NGO dealing in particular with EU trade agreements, trade relations, and raw materials. And my specialty is the ECT. I was told that it would be best to prepare the slides in English, but to speak German. So I'm just hoping that I will manage to stick to one language. I'm going to talk about these 4 topics. I'm going to speak to 2 more basic questions, the topic of ECT and investment protection agreements, and what their relationship is to the energy turnaround. And then I also wanted to talk about the reform, what we're critical of, and also going to talk about what Christina said, new technologies, new energy sources, and also the expansion of the ECT to the global south. And then I'm going to take a look in the future, to the future. So let's go back to more general topics of what and what we're trying to do with ECT. I would like to just start with this, the following question. We have this broad area of global energy. There are always winners and losers, and it is about a lot of money, especially in energy, where investments are usually high, especially also true for fossil fuels. And in science, there's a concept that's called stranded investments, stranded assets. So assets in which you have invested money on the basis of public stocks, but because of changes in policy, etc., they lose their value. So who should bear the cost if suddenly these assets change their value, lose their value because of public measures and not just a change in markets? Should that be borne by the public or by the owners of such assets? So our worry is that treaties like the ECT shift that balance to the taxpayers, so that the public then has to compensate private asset holders who lost their investments, even though they often invested very late, when it was already clear that because of having to fight climate change, it was clear that these assets would lose their value. And then the second question is, who should decide on the distribution of such costs? And then I would say that the ECT is an example of what not to do, how not to do it. And then we have another area where we have a lot of investments, renewable energies. So again, the question is, what about ownership? What type of ownership do we want to support? And who should receive particular public support? And I would say that we would like to now create a society with more equality, and the ECT does the opposite of creating more equality. I'm just going to show you a graphic just to illustrate the amounts. So for gas and oil, we're talking about more than $1.4 billion in assets that would be lost. if we want to get the world on the path to 1.5 degrees only, warming only. So this is we're talking about a lot of money. And then I wanted to give you an example of how the ECT comes into play. So we are going to compare the coal exit in two different EU member states. So we have the Dutch coal exit. The government and the parliament decided how they wanted to leave coal by 2030, and they adopted a law with compensations. And RWE and Uniper, these are the largest companies with such investments in Dutch, were the first to threaten to sue before the act was actually adopted. But then when it was adopted, they did sue. And they asked for 2.4 billion euros compensation, and Uniper now has to take that claim back because of a counterclaim. Germany, they did it differently. Rather than having a decision by the parliament and the government, the contract was adopted between the coal companies and the government. And so the companies signed a waiver, so no claims under the ECT, but in return, they received 4.53 billion euros for the phase out, 4.35 billion. And one reason why that was such a high amount is that they signed this waiver to claims under the ECT. So you can see how much such a claim can be worth. So the government can choose whether they want to risk such claims or whether they give in advance and just pay compensation. And this is such a high sum that the European Commission has started a support procedure, because they are now saying they're suing Germany because they're saying it's an inadmissible public subsidy. And here we have a communication by the Ministry for Economy from 2019 to the Chancellery. So you can see it says that in particular, it is to be expected that companies are not just going to claim at the national level, but also claim at international arbitration courts, and that these procedures will consume a lot of money and time. So, but we have also seen lots of cases in the area of renewables, and then often it's assumed that that's a good thing because it's about renewable energies. But from our point of view, and we've published a study on this as well, there are several aspects that shouldn't be forgotten. So for one thing, there's no evidence that treaties like the ECT actually lead to an increase in investment in renewables. But at the same time, these treaties allow investors to lock in high investments, and later on, it's very difficult to change that by means of public policy. For instance, in Spain, there is a lot of money that they tried to claim via the ECT. And this also discriminates against local or domestic actors, investors. So supporting cooperative approaches will always be a disadvantage to foreign investors, because foreign investors can claim under the ECT. So many of the claims in Spain came from major investment funds and financial investors. And many of those, at the same time, invested in fossil projects as well. And the European Association for Renewable Associations has also suggested to leave and demanded to leave the ECT. This is a text by Philip Sands, a major economist. Some of you may know his books. Sometimes he's an arbitrator in such courts, and he says that the ECT is a kind of insurance mechanism that allows claimants to benefit from a regulatory framework that is too generous and creates windfall profits. And it also leads to renewable technologies being more expensive than they have to be, than need to be. So it actually hinders investment in them. And this slide is a brief overview of the reform project for the ECT and our criticism of it. Most of it has already been said tonight. But one major issue is that the EU Commission, the EU member states and the UK stipulated that existing fossil fuel investment will be protected for at least another 10 more years. So 10 years after entering into force of the treaty or application of the treaty, and we don't even know when that will be. That could be a long time until this reform enters into force. Last time it took 12 years. It could be quicker, but it means that this treaty is definitely not Paris compatible, because protection for another 10 years means that measures that are taken within those 10 years will still be protected. So if 2033, a new measure is taken for climate protection for the year of 2040, you could still sue under the ECT. And then another issue is that nuclear energy will be protected indefinitely. There was a major claim against Germany and also some gas investments until 2040, and then under most scenarios that isn't Paris compatible either. And then the state settlement dispute settlement mechanism, the ISDS, has remained completely untouched, even though the EU had pledged to never join another treaty with this unreformed mechanism. And then the protection standards are too far-reaching, and they also go beyond the German coalition agreement of the current government in Germany. And these arbitrators are very creative in reforming or changing their standards in order to get protection even for areas that are not in the sense of the original treaty. And in terms of expansion, Christina has already said it. So within the reform, they want to also include new energy sources, among others, hydrogen, biogas, biomass, and CO2 carbon capture and storage. And these are not always clean as such. There are a few further criteria that have been included in the reform, but we're still just looking for the right technologies, and to just label these as climate friendly and include them in the treaty isn't the right way to do it. And there may be new technologies that are still quite vulnerable to such ISDS claims, and they're exactly the type of technologies where you need initial governance support just to then get to a stage where they're mature enough to fly themselves on the market. So there could be overcompensation for private actors. And then once that's stopped, such claims could come up again.
Diese Technologien zu entwickeln und auszurollen.
So there's no indication that we do need that for the purpose. On the expansion of the ECT, I brought a map to show you West Africa, for example, including Morocco, and then quite a number of states in East Africa and Southeast Asia. So the expansion would be going towards the global South. And even if if we imagine that such claims are a real challenge to the administration of Germany, for example, you can perhaps imagine how problematic such treaties would be for countries like Nigeria or similar countries. What is the outlook? We've already heard that 4 or 5 European governments already announced that they wish to withdraw. The Slovenian government has also voiced similar intentions. Germany is the most important holdout, basically. And we've heard from many others that they would probably go along if Germany decided to quit. And that is why I would like to invite you to join our campaign to Scholz, Habeck and Lindner with a good explanation and plenty of arguments on why we wish to quit the ECT. We think that definitely Germany should exit this treaty, but we'll see what the ministerial discussions about this step will bring. Christina has already explained why Germany should probably quit the ECT. And then we need to see whether the ECT in itself will survive or whether it will simply come to an end. And then let me move to my last slide. Whatever happened with the ECT in the past few years is quite remarkable. A few years ago, nobody ever spoke about it. Many people thought that fossil fuels should no longer be protected under this treaty, but now there seems to be a real shift towards further protection of fossil fuels. And we think that we really need to use the momentum, the dynamic of the present times to move forward and simply withdraw the protection of fossil fuels. So we know the CETA, the EU-Mexico and other agreements, they don't have any special exemptions for fossil fuels, and therefore we should really be coherent in the contracts between the European Union and others. And the sunset clause is still included. Obviously, we do have 2,500 plus investment treaties, but many of them are being used to bring claims. And if we could perhaps finish the present ECT and reconsider other such treaties, then perhaps we could really prevent further risks from the climate or for the climate and further damage from the environment. If you have any further questions or if you wish to take up the debate with us, here are the details. Thank you very much. Thank you very much. We'll definitely make the slides available after this webinar. I can see many questions, but some of you may perhaps be wondering why we only have 3 inputs. We did try to invite someone from the European Commission or also from other organizations who would definitely be speaking up in favor of the reform or in favor of the exit. And unfortunately, nobody was available. So it would perhaps be very interesting to look at the position of someone who actually thinks very positively about the reform. We have many questions already, and I'll try to take them up. I think it was really fascinating to hear what you said. Margaret Streifeneder asks whether an exit of the treaty would have any negative consequences, and someone says yes, to develop a global movement would certainly be good. But Christina, you were talking about the justice and you were talking about the climate. If all the EU member states were to exit the treaty would still be there. And it would probably still apply, at least the old treaty would still apply, and 40 new states would probably join it. But if we now said, we are no longer with you, we don't approve of the reform. Fabian was talking about the sunset clause. What would really be the negative consequences of these future steps? Perhaps you could elaborate. Christina, and then Anna, and then Fabian. Yes, thanks very much. I would like to come back to the sunset clause, which we call the zombie clause in German. That means that you quit a treaty, but the treaty still applies to your state for another 20 years. And the proposal of the Commission, and that's not only the tendency, but it's also the procedural approach of the Commission. We need an interstate modification agreement, which means some of the states that may quit, and for the EU itself, we would have a number of countries perhaps quitting the treaty, and they would have to agree amongst each other that they would no longer use the sunset clause or the zombie clause, whatever you wish to call it. So if that was to be agreed between those member states, then the sunset clause would no longer be applied among those states. And hence the question arises, how many states will quit the treaty? If many states quit it, then it would be very effective. If 2/3 were to quit, for example, we have so many proceedings, so much litigation going on, and we don't know all the cases because many of those disputes are settled outside of court. So you have 150 that are brought within the European Union. So if we don't have that intra-union agreement not to apply the sunset clause, it would still apply. What happens if the EU withdraws on the 22nd of November? Well, you can vote against, but you can also abstain. The Netherlands already announced that they would be abstaining because they say that the reformed treaty should remain open for the other member states, because they do consider the newly reformed treaty a better one than the old one. To expand it to the renewable, expenditure of the renewable energy sources, that and to broaden the arbitration to other areas can also have some negative impact. We've heard the arguments. Whether that really is more positive, the reformed treaty or not, remains to be seen. I don't agree with that assumption. But anyway, the treaty could continue to exist if the Energy Charter Council and the ministerial representatives will have to vote on it. They will have to reach a quorum, and all of those who vote will have to give a unanimous vote. and only the countries who actually vote, in fact, would have to vote in favor or against it. If they voted in favor, then the reform would not be stopped on the 22nd of November. Whether, however, the 40 states will then join or not is a different question altogether. Nobody really knows. If you look at the study of Columbia University and the Institute for Sustainable Investments, then investment treaties do not necessarily generate more investment. That has been found in this particular study. So we'll have to see whether those states will still be willing to join the treaty. They would normally do it because they expect that investments would pick up. But if the European member states quit en bloc, then the question remains whether it's attractive to join. And I'll directly pass the floor to Anna. Yes. Christina said quite a lot, but I would also like to share my views on this question. And I think it is very important to point to the negative effects. And it's very good of you, Max, to be the advocatus diabolos. It's not so very clear and not really very simple to grasp. And that is why I said at the start that it is very difficult to withdraw from the treaty and to reform it. That's why such treaties will have to be construed differently in the future. The Commission says an exit is worse than the reform because we would still be under the old treaty for another 20 years. Fossil fuels would still be protected. And the reform says new investments in fossil fuels will not be protected from tomorrow onwards. Others, older investments, will still be covered for another 10 years. But there is no guarantee that really after 10 years, the protection of fossil energy sources will be stopped. The European Commission says that we can only diminish the risk or eradicate the risk of intra-EU proceedings with the reform, and then avoid litigation altogether. But others say no, the withdrawing from it would perhaps be the better way, but legally speaking, the Commission claims that the reform would actually offer legal security. One of the major setbacks of the whole reform is the expansion of application to more countries. And if you discuss it, then many people think like the Netherlands. Well, if you want to quit it, why don't you quit it, but leave it to the others? If they want to remain a member or not, they should decide that for themselves. And there's a lot which is regulated and well regulated in it. So everybody should be able to legislate themselves. So the Commission still says, let's reform it, and whoever wants to quit, quits. And other people again say that just blow it up, blow it up, so everyone will quit. But in order to withdraw from it, you need a qualified majority. And if there aren't enough states to opt for that direction, then the EU will remain a member. It is really very complicated, and there are no simple answers to the whole question. In my personal opinion is that exit is still, despite all the difficulties, the best option.
Thank you. So that was very clear. Fabian, would you like to add to that topic, and then we can go to the next question? Well, a lot of things have been said. Just wanted to add one thing and confirm the suspicion that I think Christina had. At the moment, they're trying to convince countries of the Global South to join the ECT by telling them that this will get them investments from Europe in their energy system, and that they're then part of a global platform to discuss energy issues. So that's basically the PR that the ECT present to the Global South. And a colleague from Uganda told me that the government was very close to joining the ECT, but now suddenly they're a lot more hesitant because they're saying, well, France, Spain and the Netherlands, if they're all leaving, who's going to invest if such countries are leaving, and maybe more are to follow? And then also they're getting the impression that maybe it isn't such a good treaty if other countries want to leave, really want to leave. So joining is becoming a lot less attractive. And there's no proof that it actually leads to more investment, which is why so many countries of the Global South have become more and more critical towards such treaties, because they've realized that these don't necessarily bring any concrete advantages, but they bring expensive claims. So just for the Global South alone, it's very important to leave the ECT behind. And then the question when to leave, how to leave, advantages, upsides, downsides. So if we leave and we use the inter-se agreement amongst the European member states, that would mean that new investments will not be protected, no matter in which area, fossil, renewables, nuclear, whatever. Any investment after leaving would not be protected, and that in itself is a great advantage. And for standing investments, these 10 years would then be reduced to 0 with in the countries which are leaving with that intra-European agreement. So these are advantages. These are the upsides. And I think that Christina is better placed to react to EU legal questions, but the way we see it, it would be very important for the entire EU to leave, because otherwise it would be so complex, responsibilities, competences, who can sue whom. And the Commission keeps telling us that there's no majority for this. But I am wondering, what happens if Germany announces that they're leaving in the next few days? Several governments have said that they're waiting for Germany's government to decide. Might that not trigger a majority for leaving? That's a question that I'm wondering if that could be the case, and that would be the best solution. Christina, directly in reaction, just one sentence. There is a legal obligation to leave the old ECT because it is not compatible with European law. So even if there's no majority, the obligation stands. So if we cannot reform, if the Commission's proposal to agree with the reform on the 22nd, then we're left with the old ECT, and then all member states are under the obligation to solve this illegal situation, because the European Court was very clear that this is a situation that is incompatible with EU law. It's not just a political question, it's also a legal question. And of course, we could add, and that's another really important point, new fossil investments in fossil fuels will no longer be protected after the 23rd of August, but only in Europe. So if we see investments in gas, oil in other countries which haven't used this opt-out, then these investments will still be protected.
Fand ich auch nochmal ganz spannend. Also es gibt
that's very interesting. This is opt-out optional scenario. So we cannot stay in the old ECT because the court has said no to that. So we have to reform the ECT or we have to leave. So let's look at some of the questions from the Q&A. I think we've looked at the various different scenarios now. And another important question is, how do these arbitration courts work? Just to get an impression, maybe to connect two such questions for Christina, maybe also Anna and Fabian. Dieter Ulrich, the top question, is asking, how binding is such a judgment for an arbitration court? If Italy doesn't pay, how will they recover the money from Italy? And then Andreas Szusewski is asking the question from the other point of view. So he's saying the European Court of Justice, with its judgment, says it's illegal to claim between European states. But these proceedings are continuing, and very few arbitration courts are actually willing to follow the Court of Justice's judgment. So how strongly are the arbitration proceedings bound by European law and by the Court of Justice judgment? And how strongly are European member states bound by arbitration judgments? That's very interesting, because if the arbitration courts just say we're not really interested, then that's a democratic problem, a problem of legitimacy. Well, from my point of view, they're a democratic problem anyways, because they just look at questions outside of the normal constitutional framework. And others, Anna has said it too, it's not about the values that we have agreed on as a society, but it's only about protecting investors against a completely different backdrop. And from my point of view, in any case, we have a question of legitimacy here. And arbitration courts are not bound by European law. They function under the ECT. Also in connection with Eckes, etc. But so they are only bound by the ECT. So what the European Court of Justice says, that can only speak to the relationship between European law and the ECT. But then the ECT says that they take a preference unless a government, the EU, decides to protect investors even more, so go beyond the ECT. So otherwise, European law is just seen as the law of a contracting party, and then it doesn't take preference. It doesn't override the ECT, and the arbitration court will say, I will apply the ECT. I'm not really interested in whatever the European Court of Justice has to say, the ECJ, and that's why they continue these proceedings. The question is, can we stop it with an intra-European agreement, an inter-se agreement, because that wouldn't be European law, it would be international law. And then we have the Vienna Convention on the Law of Treaties and the option for contracting parties to agree on an amendment or on concluding the treaty between themselves, unless they actually undermine other contracting parties' rights by doing so. So that would mean that we can only get rid of the sunset clause with the countries and parties who would agree to that inter-sea agreement. So we wouldn't get rid of the sunset clause with Kazakhstan and Japan, but it would be the EU member states, but maybe we could get the UK and Switzerland on board too. So that would be another option. So just another question on that, because it's also something in the Q&A. With the inter-sea agreement, if that was would be international law, would that also put a stop to ongoing proceedings or future proceedings only? That's a difficult question because it depends on what the inter-sea agreement would say. What can we agree on? What can we stipulate in such an agreement? Well, I believe that legally speaking, it might be possible to stop them immediately. So this is about the rights of the parties. So that means the states. If they agree that individual investors would no longer have the right to continue their claim. But of course, there could be a political answer to that. Uniper claimed, and then they got the support from Germany, and then they withdrew their claim. So the question is also how much pressure and what's the relationship between states and investors. But legally, international treaties are treaties between states and rights and obligations of states, not of investors. Thank you. Would the others like to react to that? Maybe also the question from Dieter Ulrich, because we only looked at one question. So how far is an arbitration court judgment binding for Italy? What would happen? Who would come to recover the money from Italy if Italy would just refuse to pay? And then the question by Anna Moreno, and I'm looking at Anna. Why hasn't Germany already announced they're leaving the ECT? Are they going to? So could you maybe say something about the discussions in Berlin? I think that could be interesting for many. The conflicts in the coalition, you may know something about that. So these two things, so how binding arbitration court decisions, who is going to actually recover the money, and then the German government's position. So how binding it is, I think that Fabian can also add to that, but my experience is that the governments tend to pay it. And especially in investment protection, the implementation is really at a very high level. If I look at other treaties, rights of women or human rights, the protection of rainforests, that is in practice a lot less well implemented than investment protection, even if there's no police force to actually collect the money and enforce it. But it's about reputation, because states are afraid of losing investors, scaring them away. So as in my experience, I don't know if I know all the cases, usually states tend to pay. And on the position of Germany, Fabian has said everything. The negotiations are ongoing. I don't think I can say more. There are 3 partners in the coalition, and for many things, they have to come to a coordinated position. I think the position of the Green Party is well known. Thank you. Christina has raised her hand. So just on the first part, enforcing these arbitration court awards, you can actually enforce them at the national level, national court, and they then can't talk about the content of the decision. So you just go to a national court. That's your legal way just to get the compensation money. So that's the difference to international law, where it's often not possible to really implement. It's just the value of any sort of entitlement and you can use that just as under German civil law. But then, of course, you have the judgment by the European Court of Justice, and that makes it complicated again, because they say such awards between two between an investor from one EU state against the government of another may not be enforced by a national government, because that is violation of EU law, and EU law has precedence over national law. So the problem is that you could just go to another national court, for instance, in Texas, in order to collect the money there, but using freezing foreign assets. So you can go to a court, a national court in another country, but a national court in a member state may no longer enforce an intra-EU award. Thank you. Fabian, please. Just to make this a little clearer. So there are always examples when states don't pay, and then lawyers just start looking for assets by the state in a different country where they don't have diplomatic immunity, and they just confiscate it there. It could be planes by a state airline, state-owned airline. It could be trademark rights or other rights that a state-owned company has in a different country. Even space travel was affected because Russia, a few years ago, did not dare to start their rockets in other country because they were afraid of them being confiscated. So it can really affect the agency of other countries. So works of art that have been loaned to museums in other countries. So of course, the same law firms that make a lot of money with the awards will also make a lot of money of confiscating these assets. So there's a conflict between how we see the situation and the Commission. The European Commission sees the situation. The Commission says we've mentioned the right to regulate, the Paris Agreement on climate protection, and all of these things. So the arbitration courts cannot take these decisions anymore in the same way. But our experience with the last 20 years is that the arbitration courts always find a way to thwart such attempts by states to limit their decision-making room. So it really goes quite far. So if we, even if the government of the country of the investor and the government of the state that is being sued says that we have to, even if they both agree, this is what we meant with this clause. We both agree, this is what's meant, this is how you have to interpret it. The arbitration court can say, no, I mean, you can agree on that, but we see it differently and we're going to interpret it differently and you're still liable. So we really have zero faith in these additional clauses after the reform, and that they're really going to help. There's always going to be a smart solution by these lawyers in the arbitration courts, because that's a financial advantage to them to have more cases, more expensive claims. And in order to put a stop to that, the best way is to leave the ECT. And the more you can restrict the 20-year period, the better. But we believe that the Commission is like the hare and the hedgehog, always trying to make small improvements here and there, but never quite catching up. Thank you. I'm just looking at the various questions. We have 46 questions at the moment. And I mean, a lot of them have already been answered. That's why I'm just trying to find something new. It takes a little moment for me to scroll down. Well, this could be interesting. How are these arbitration courts instituted? Who nominates the members, the judges, etc., and who are they? I think all of the other questions, most of them have been answered. There's another question to Christina by Gertrud Falk that I don't really understand, but 29 others have voted it up, so they must understand it. So I'll just ask it. Can companies also sue government or states because after leaving the ECT or for leaving the ECT? So that's a question, and maybe the other question about how arbitrators are nominated for an arbitration court. Yes, of course, I can say something about that. I think there were several questions by Gertrud. I'm going to try to find it. So there's private autonomy. The parties, the investor, and the state can find the arbitrators and nominate them. And these are not judges, so they're not always going to be paid, no matter how many cases they deal with, but they are going to be paid by day. So it motivates them to find every claim admissible. And such a fee, a daily fee for such an arbitrator is about $3,000 per day. And if for a proceeding that runs for 3 or 4 years, even if they don't work on it every day, that's very lucrative. I'm not saying that all of these arbitrators just work because they're greedy. That's not at all what I'm saying. I'm just saying that there is a financial incentive for them to admit cases, to make sure that they take a while, and that makes them money. So I'm also saying that it's the parties, and an arbitrator is going to be chosen by investors if they favor investors, and they're going to be chosen by a state if they are well known for making quite balanced decisions. And the problem here is what we've seen in the past. Even though we have some parts on climate change and climate protection in the ECT, without any sort of that having any sort of effect on arbitration courts and their decisions. The other problem is that there's no coherence, because the arbitrators change with every case. They're being chosen with every case. So you don't know what the result of a case might be. So there's the phenomenon of regulatory chill. Whenever a state thinks about adopting climate protection measures, they have to think about the financial impact. And then another point, it's not always about money. In the past, there have been proceedings where the arbitrator said that, for instance, that it wasn't necessary to do an environmental impact assessment, and there was Vattenfall against Germany. How many water from the river Elbe can be used for cooling the nuclear plant? And Vattenfall was then allowed to use much more water from the river than Germany wanted. So there can be material consequences, not just financial consequences. So even with a settlement, that means when both parties agree before the decision of the court, but even after the decision of the arbitrators, there can be material consequences. So environmental protection standards or climate protection standards are often less ambitious because of that dynamic. So this is the question: can companies sue states when they leave, if they leave the ECT? I don't know how. Just let me think briefly. So would these be companies from the contracting party that's leaving? I would say no, because under international law, the state is allowed to make this take this sovereign decision. And the ECT has an article that allows contracting parties to leave. So it does not infringe against international law if you leave the ECT. As an individual person, you can only sue a state if they infringe upon your rights, but international law is quite clear. So this would not be illegal. So I think we're close to the end. We have 3 more minutes. Fabian, maybe a few words. You posted a few links as well. So, and then we're going back to Anna as co-host, and maybe she also has a few words for us. And before I forget, I would like to thank our interpreters, says the speaker, and we're happy to have listeners. So let's start with Fabian and then Anna. Yes, I'm going to be really short. I believe that we have an opportunity here to achieve something really important, namely for the EU and or most of her member states to leave the ECT, and that would have a symbolic effect because these are the countries that were usually on the side of the companies, and the companies that were suing were mostly from Europe. So Europe really is the core of this entire system of investor protection. And many academics say that this is a massive barrier to achieving our climate goals, with the ECT being a big part of that. So it's really important for us to leave. And that's why I would like to motivate everyone to do whatever you can think of to motivate your members of parliament, etc.
Aus diesem Vertrag auszusteigen und allgemein den Investitionsschutz
to really step out of this treaty and to end the protection for fossil fuels. That should really be our main objective. Thank you for the invitation today. Anna, very briefly only, I would just like to add that I'm very happy to see that so many of you stayed with us in this debate. It really is a very important debate on international investors' protection, but this also has to do with the very basis and foundation of our democracy and the state of law in our individual member states. Just like Christina, I think it's magnificent that this dynamic developed. I never expected that to happen, as many others who have been fighting actively in this area. And I would really like to thank you for having shown up in so great numbers and to have participated in this debate. And I think it's very important to carry on working on it and for that objective in the media, the social media, and amongst ourselves. Thanks very much. I don't really need to add anything to that. I would really like to thank you. We've still had 500 participants at this very late hour, and I would just simply like to inform you that we will be continuing with Europe Calling on next Monday from the German Embassy in Prague, live from Prague on Eastern Europe, the energy security and other questions. I have just posted the link into the chat, and I think it'll be fascinating to follow Europe Calling next Monday evening. Until then, stay safe. Thank you very much for your great interest. Bye-bye. See you next time.